Welcome back to Legal Principles of Surveying, Spring 2014. My name is Chris Riles, and I am your instructor from East Central Community College in Decatur, Mississippi. We're going to be talking about Chapter 5 in Brown's Boundary Control and Legal Principles, talking about meets and bounds description, their creation, and interpretation. Now, your book calls meets and bound descriptions non-sectionalized descriptions. We're going to talk about what that means, but basically, it means that they weren't subdivided into the PLSS sections originally. Now, the history of meets and bounds. The oldest form of boundaries identified by landowners and surveyed by surveyors and litigated by lawyers and the courts have been and are meets and bounds boundaries. That's from your textbook. Meet means measurement. It usually refers to the direction and or distance. So, for instance, an example of such and such thence north 640 feet would be a meet. So I am measuring something, a meet. A bound means a terminus, an ending point, an intersection, a vertex, something, a point or some kind of monumentation or corner that is existent. Okay, this could be rivers and streams, oceans, trees. Many different things have been used for bounds in the past, and some things like your trees, well, they may not exist after 200 years, and so we have to really think about what we use as a bound today, but we also have to look at what they used in the past. Meets and bounds descriptions are thought to have began in early Egypt and were later adopted by the Roman Empire. Since mankind started land ownership, a system of defining the boundaries of that ownership had been needed and required. Once land started to be owned and people started to stake out their territory, there was a need to be able to mark and define this. An early description included major bodies of water as landmarks or other kinds of boundary monumentation using bodies of water. For instance, you would go from one place that had a river or a branch to another place that had a river or a branch. And these were based off of these water boundaries that may actually move and change. We know as well as anybody here in the state of Mississippi that rivers move. The Mississippi River, when it floods, when it falls back into the banks, it may have moved because water tries to find that path of least resistance. Well, if you're using water as a boundary monumentation, that can cause some serious issues with where the boundary is. And since these were only based on bounds, there was no real description of how far apart they were. And so as things changed, technology improved, meets were included with these descriptions to increase the accuracy. So I would say thence 234 feet to an iron pipe. That makes a lot more sense than saying from creek to creek. And under current meets and bounds descriptions are all standardized under state law. You have to write them in a certain way. You have to operate them in a certain way. You can't just make them up as you go. Now, the term sectionalized refers to land that was surveyed using the General Land Office Public Land Survey System, or as I call it, the PLSS. These lands were defined by the subdivisions and sections of townships. And we've talked about that a little bit. There's a later chapter in your book that talks directly about the PLSS description system. But remember, they use townships and ranges to define a distance from an initial point. And then you have sections that are subdivided from townships. And I think we'll be talking about that, if I remember correctly, in chapter... Let me check real quick. Chapter 6, that's our next chapter. Okay, so we'll be talking about that next, and there's a lot of history that's tied to that, and a lot of history that has defined the U.S. Well, non-sectionalized refers to other forms of land boundary descriptions and conveyances. So basically, meets and bounds is not dependent upon the PLSS, but in many states, including Mississippi, require that all meets and bounds descriptions be tied to a PLSS survey. If you'll remember, we talked about in the last lecture about using a meets and bounds description and a PLSS description together. Maybe there's the previous one. We talked about ownership. We talked about those being tied together. And a lot of your descriptions that you'll see today, if you have a meets and bounds description, it has to be tied back to an original survey, which is one of these PLSS surveys. Okay? Now, the truth about meets and bounds, these are things out of your book that I thought were really good. It'd be great if you'd highlight these and read these and kind of let this sink in. The term meets and bounds should be considered as a collective description, in that it can be a meets description, a bounds description, or a combination of both. You may see some descriptions that have an excellent meet, but they lack a bound. It may just say to a point. Well, I've got a great distance and bearing, but I don't know where it's going. Or you may have a bounds description, definite fence corner or section corner found, but the meet has a lot lacking. Okay, it may just say a distance of 200 feet. Well, we all know that 200 exactly is at .00 or 200. I'm close within a foot. GLO boundaries, however, were and are created under the law. It could also be said that meets and bounds boundaries are also created under a much older and ancient law, the common law of the unwritten law. Even though we will say that GLO boundaries are created under what we call statute law, ordinance law from Congress, you might could even say that meets and bounds is based off in an even older system. And the PLSS gained some information, and then the way it was surveyed from the meets and bounds system. The reason that we shifted to the meets and bounds is because we wanted to find a way that was easiest to transfer land from one owner to another. And that was the easiest way. We'll talk, of course, more about that as we get into Chapter 6. All right, principles for this week. We have Principle 1, Principle 2, Principle 3. We'll read them all in a minute. 4, 5, 6, and 7. And Principle 8. All right, Principle 1, meets and bounds. A landowner is free to create any boundary as long as it does not infringe on the rights of an adjoiner or on what we call a senior right. Now, this principle ties back to the doctrine of common law rights to land. I can do anything with my land that I want to as long as I don't infringe on someone else's rights to use their land. Infringement of the rights of another is a violation of the common law and also a violation of many different statute laws and federal laws. You may enjoy your rights and freely act on them until you infringe on the rights of another individual. For instance, it's not a good idea to go into a theater and scream fire, because you're infringing on the rights of the people in the theater and their safety potentially by making a false accusation. Now, if there's a fire, of course, you want to say something so people can get out. But if you're just making fun and you're making a joke, just screaming fire can cause problems because you're infringing on the rights of another individual. If the changes to a meets and bounds boundary are made by the landowner, these changes are made by the landowner, it may infringe on the rights of the adjacent or adjoining landowner. So, if the landowner gets out there and says, well, I think it ought to be moved this way just a little bit using meets and bounds, well, that could infringe on the rights of an adjacent or adjoining landowner, and we don't want that kind of infringement. That's where the surveyor comes in, and we have to really investigate and look at evidence of what's going on with the land before we proceed. Now, a little bit about junior and senior rights. It uses the term senior rights, so I wanted to give you a little bit of extra information. Basically, this concept relies on the date of sale or conveyance of adjacent parcels. So basically, the older conveyance or description, the more likely the courts are to side with that description, it being a senior right, it being there before. Now remember that a new description cannot infringe on the rights of a previous current landowner, and this is the principle of the concept. I can't create a new boundary and it infringe on the rights of an old boundary owner. That's just it doesn't make sense. I can't just create a new boundary and infringe on someone else's rights without it being conveyed. And so that's the issue here with junior-senior rights. If I've been there longer, you can't infringe on my rights and you can't affect my land ownership. I've got a link down here, surveystudent.blogspot.com. I really would like you to go out and look at that. He's got some graphics and he gives a little bit more explanation about junior and senior rights. It would help you a lot to go out and read that link. It really is helpful and really is pretty neat. All right, back to principles. Principle number 2. The lines and corners of the original survey control the location of a parcel. Okay, and this is important, that the lines and corners control the location of an original survey for the parcel. Lines are presumed to have been established in accordance with accepted rules of survey and any minimum standards in existence at the time the original lines were created. Now, because we have standards of practice, and even back in the 1830s there was a semblance of standards of practice in the law ordinances and in the acts made by Congress, original surveys are assumed to be accurate and control the location of the parcel. We still go back to the 1830s original surveys. And previous surveys that you're retracing, that you're following in the footsteps of, we assume them to follow under the standards of the time. So, surveys conducted in Mississippi since 2005 are considered to be under the current standards of practice, because June 2005 is when we went to this new standards of practice. And previous surveys from there that you may retrace are considered to be in compliance with those standards previous to June 2005. And this is the whole concept of, even though it's an older survey done with lesser technology, done with lesser knowledge, it's still going to fall under some form of standards of practice, and we still want to make sure that we maintain that or make it better, okay, when we create a new description or create new boundary lines. Now, if a survey is not conducted with standards in mind, a surveyor can lose his or her license or face jail time, and that is absolutely true. You can't go out and just ignore standards and ignore evidence and ignore information that you find. You really need to focus in on that, or you can pay the consequences. All right, principle 3. There was no standard unit of distance or angle used in early meets and bounds description or standard method of describing monument set at corners. You may see early descriptions that use units that are not currently accepted or have what we would term as a relative unit, okay? And there's a lot of strange ones. If you look in your textbook, it talks about some of the different units. Smokes. The distance traveled while smoking one cigarette. Now, this is assuming that you're riding on a horse, not walking. Or is it? Arrow shoots. The distance an shot arrow travels. Well, am I pointing up toward the sky? Am I pointing towards the horizon? Or am I pointing at the ground? Arrow shoot. An arpent could be 180 French feet or a unit of area. So it could be linear or an area. Yeah. Some of the descriptions and units that you will see in older descriptions may have some of these strange units. Now, you should understand the chain, and the chain is still used by the federal government, by the way. The BLM still uses the chain as a unit of measure. But you need to understand these units, and when you see them, you need to do a little bit more research into the way the land was surveyed. But we're assuming, based on Principle 3, that there was no standard unit used in these earlier descriptions. And so there's no standard methods, at a certain point. So we now want to use a standardized unit, and in the standards of practice, they tell us to use feet or meters. Now, the current laws regarding units that can be used for surveying have been built upon problems that stem from an early lack of standardized units, like I was saying. Examples of confusing units like the arpent were common in early meets and bounds surveys. And even now, you may find evidence in South Louisiana where the arpent was used quite a bit, especially around Lake Pontchartrain and New Orleans. You may find evidence of those units being used. Many times the distance and directions were intended to be, quote-unquote, a finger pointer. You want to go that away to the monuments or corners. And as such, the retracing surveyor should investigate beyond the distance and direction, and also shorter than the distance and direction, and look for evidence of monumentation. I think I may have said it before in class in one of these lectures, but when you have a legal description, that's a finger pointer to where the monuments are. It's like a scavenger hunt. You want to use the legal description so you can find as many of the monuments as you possibly can. In many cases, there may be more monuments than are called for in description, and in that case, you need to survey in each and every one and then dictate what they are on the plat. Principle 4. Words and their meanings and distances recited in a description are to be interpreted as the date of the description, not as of the time of the retracement. I cannot express the importance of recording date along with data collection. When you're processing data, when you're collecting data, get the date down. Whether it's in your data collector, whether it's on a notepad, whether it's you're writing it on a piece of paper, get the date down when you went out and surveyed a piece of property. Because of the passage of time, evidence degrades, as well as information regarding boundaries. If you go out and set control corners and control points, and then you take a month to go back, well, those points may not be there anymore. They may have been pulled up by a lawnmower or eaten by a horse or whatever. And so you may not have them with you anymore. All information contained within the description is to be interpreted as the date of collection. And our standards of practice, if you'll remember, in the very end, ask for the data field survey in section P. And so it's important to write that data field survey. Evidence such as compass bearings, distances, natural and man-made boundaries and monuments can change over time. And so it's important to understand the intent of the surveyor. Even though time may pass by, even though measurements may be in funky units, we still want to look at the intent. What was the surveyor intending to do back in the gap? For a corner and its monument to be controlling in a description, the corners must be called for in the written conveyance and the monument identified at the time the conveyance was made. Now, I want you to soak that in for just a minute. A corner and its monument. Corner, remember, is on a piece of paper. It's on the map. Monument is a something in the ground. We assume to be at minimum a half-inch rod, 18 inches long in Mississippi. For it to be controlling, it must be called for in the written conveyance, which means anytime I write a description, I must include the composition and an adequate description of the location of each monument that we set or that we locate. For instance, I recently did a survey where there was an iron spike in the middle of the road. Now, by parole evidence, they knew it was there, but the road had been repaved. And so what we had to do is go out and actually dig up the location under the asphalt of that iron stake. And then once we got the evidence of the iron stake, we shot the iron stake in and used it as controlling in the survey. We then included it in the description and on the plat. The more information you can include, the easier it will be for the retracing surveyor to follow your steps in the survey. The more meticulous you are about marking your evidence and looking for evidence, the better off you'll be in the future, because you may retrace your own surveys later on down the road. Principle 6. In a meets and bounds description, a boundary or property corner should not be placed on a curved line. Now, today we can use technology that's a little bit fancier than they used to have, but still we don't really want to place boundary corners on a curved line if we can help it. Locating a point along a curved line is much more difficult than locating one along a straight line. For those of you that have taken my advanced surveying class or have done them in the field, to do a horizontal curve and to stake out a horizontal curve is a lot more math and a lot more thinking than staking out 2 points along a straight line. That's just the way it is. This principle stems back to the ability to retrace the monument in a future survey. If the location of the monument is ambiguous or lost due to the passage of time, it's going to be difficult to retrace this monument, and it may not be able to be retraced at all. And so that can just cause issues for the future retracement surveyor. Specific instructions on the exact location of a monument are vital to retracement, and retracement along a curved line can become ambiguous. How far along the line? In a northwesterly direction? What kind of direction is that? And so if you don't follow the standards of practice on locating a curve, giving the radius, giving the chord, giving some information, the 4 parts of the curve, if you don't do that, then it's going to become very, very difficult to retrace. Modern descriptions may include coordinates for each monument. I don't do it personally, but I know of individuals who use coordinates for every monument they set. That's kind of a preference thing, but I do believe in the future there will come a point where every monument that you put in the ground will have to have a state plane coordinate tied to it. I don't know that for a fact. I think the legislature will decide that, but I think we'll start seeing that more and more as technology improves in the future. Principle 7. A boundary line may be created by words in a legal document. That line is as binding and as legal as if it were run on the ground by a surveyor. And you see this a lot of times. A lawyer can give a boundary description, or a court decision may give a boundary description that may never involve a surveyor. Okay? Boundaries may be described and created by law. Remember, there's another form of creation. You've got action, you've got law. I'm trying to think of the third one. It escapes me at the moment. Some of y'all can scream it at the computer while I'm trying to think. Anyway, action and law are 2 of the 3. These instances could be decided without the surveyor when it comes to law, because remember, we're not lawyers. We don't have anything to do with the law other than we follow the law. We just abide by it. Many times these descriptions are sufficient for rural surveys or descriptions based on PLSS descriptions. So if I have the northwest quarter of the northwest quarter of Section 8, well, that description is a PLSS description. There's no need for a meets and bounds. And if I'm just transferring the land, there's no problem with it. However, if the one writing the document has little or no experience in land law or understanding descriptions, that description can also become ambiguous or misunderstood. There are many cases that I have seen where descriptions overlap each other and nobody realizes it because Nobody did the title research and looked back. Also, it's so easy, and I've done it numerous times, to change a north to a south or an east to a west. And if you look at it long enough and hard enough, you may miss some stuff, okay? It's the responsibility of the surveyor to retrace the boundaries, even if they are written by a legal document. We still have to go use those and retrace them and find as much evidence to prove the fact of the boundary being in its location as it is written in the legal document. Principle 8. In conducting a retracement survey of a meets and bounds boundary, the retracing surveyor must be knowledgeable of and apply the priority of cause. Now, the priority of cause is a principle that stems back to ancient land law. What controls, which part of a description controls more than another part of a description. The surveyor must take the evidence that is at hand in a meets and bounds description and do his or her best to order the parts of the description by what controls. So we want to look at a description by what actually controls on the ground. Now, the term control means that part of the description that has priority in locating the actual intended boundary. What part of the description controls is directly related to its importance in the description. So, to give you a little bit of information, this is a general summary of what controls and the order in which they control, okay? Starting at 1 and going to the end, 1 being the best control and the end being the worst kind of control. Now, this all came out of legal descriptions written by Waddles, Writing Legal Descriptions. It's the 4th edition. You can find them on Amazon. They're little yellow books. I also gathered some other information from Surveying Boundaries by Surveying and Boundaries by Clark, the 6th edition, written by Walter G. Robland and Lane J. Bowman. Now, this is some information I got from them. This is not in your book. Once again, I say this is not in your book. This is just a general summary, and state law may change these based on where you live. As far as I know, Mississippi has no law on this, but I'm not a lawyer. I don't know that for sure. The first control, a natural or man-made monument which has been called for in a description. Now remember, we talked about that reciting it in a description. Remember that? The more these are recited or called for in a description, the more power they have as a control. If the southwest corner of, the northeast quarter, of Section 8 has been called for numerous times throughout the years, that's going to control more because it's been used numerous times and found numerous times by multiple surveyors. Notice that it's called for in a description. If it's not called for in a description, it doesn't classify here. Now look at number 2. Man-made or natural monuments which have not been called for in the description, but have been cited in other forms of evidence. One that's not called for directly in the description, but is cited as far as being on a map or a plat or in someone's field notes, that one controls next. Okay. Number 3, a called for boundary of record. Now this may be a township or section line or other form of boundary. Some kind of boundary or record that has been called for, giving a distance and direction based on that, or just a boundary such as a boundary between counties or a boundary between states. Okay, it could be any kind of boundary, macro or micro. All right. A called for distance, number 4, called for distance and bearings that tie boundaries or corners or monuments of currently recorded property. So if I have a tie-in using a bearing and distance, okay, to other corners or monuments based on a boundary's location, that will control at number 4. Number 5, distances along a boundary without any ties to monuments or corners. If I have a distance, the distance controls over direction. Notice that bearings are number 6. So when you look at a legal description, the monumentation is the one that controls the most. That is the number 1, the top. And as we trickle down, we see that distances control over bearings, bearings are under distances, and the worst thing that you can control by using a survey is area, because area is the, if I'm going to measure something, a meets and bounds description does not contain area until the very end. It gives me bearing and distance all the way around. Well, area is the worst thing because area can be in many shapes and forms. An acre can be many shapes. It doesn't have to be a 4-sided little square. Okay, so that's kind of a general summary of what controls. Real short lecture this week, only 21 slides. The chapter's kind of short. There's some stuff in there. I would definitely read the chapter if I were you. Remember, this week we have our first exam. It's proctored. You need to be signing up for the exam and taking it. That quiz 5, we're going to wait until next week to have quiz 5. We'll have it with quiz 6, and we'll have them together. And the semester paper assignment, I'm not going to put that up until next week as well, because I know we've got a lot going on this week, and you've got the test that you're taking. So consider those things to be put off until week 6, week 6, when we start talking about chapter 6. Hope you have a great week. Hope everything goes well for you. Do well on the test, and we'll talk to you later.